going to ask you a few questions. Would you state your name for the court, please?
Nikki Harris.
And what town do you live in, Ms. Harris?
Columbus, Ohio.
And am I correct, you live with your daughter, who we're going to refer to today as DH by her initials?
Yes.
The reason we're here today is because your daughter was involved in a tragic car wreck on July 12th of 2020 outside of Houston while she was visiting her father over the summer, correct?
Yes.
In that lawsuit, not only was your daughter injured, but you lost your son.
Yes.
It was a single car wreck where the car hit a barrier, and that's generally what happened in the wreck, correct?
Yes.
Your daughter was taken to Memorial Hermann Woodlands, but then transferred to Memorial Hermann downtown, correct?
Yes.
Your daughter primarily had a pelvic fracture and liver lacerations, correct?
Yes.
And while it was, understandably traumatic, she has made a great recovery from those injuries, is what I understand. Is that correct?
Yes.
You understand and are familiar with the claims that we brought against Dale Maurice Huffman for our allegations of him causing the wreck, correct?
Yes.
You've read the lawsuit that we filed and understand the claims that were made, but you're here to tell the court that you'd like to settle the lawsuit, correct?
Yes.
You understand that if the court approves this settlement, there will be no additional funds for your daughter. No matter what happens in the future, we will not be able to come back to the court, the insurance company, or Mr. Huffman to ask for more compensation. You understand that, correct?
Yes.
You understand that rather than having a settlement, we could have a trial where we ask a jury to award damages. And while I expect a jury likely would, that wouldn't change the amount of minimal insurance Mr. Huffman had. You're aware of that too.
Yes.
You would like the court to approve the settlement rather than have a trial, correct?
Yes.
As your attorney, I've fully explained your obligations and duties under the settlement agreement that we've talked about and are talking about today, correct?
Yes.
You understand what you have to do and your duties in that settlement agreement that you will sign, correct?
Yes.
Do you believe that this settlement is in the best interest of your daughter?
Yes, I do.
You understand that if any medical bills were to surface that aren't dealt with by this settlement, they would be your responsibility. They will not be paid by the defendant or the insurance company, correct?
Yes.
Well, while obviously not happy about the amount of the settlement, you are satisfied that given the circumstances with the figures in the settlement, correct?
Yes.
You understand that Mr. Huffman had a policy of liability insurance in the amount of $30,000, and that total amount has been offered to settle this case, correct?
Yes.
You approve that you would like to accept that amount from Mr. Huffman's insurer, Geico, correct?
Yes.
Out of that $30,000, you are aware that my firm's fee was 1/3 or $10,000, but we agreed to reduce our fee to $7,500. Do you approve and ask the court to approve that fee for my firm for the work we performed?
Yes.
You understand that in prosecuting this case, my firm had expenses of $644.14. Do you ask the court to approve reimbursement to my firm that amount for our case expenses?
Yes.
Your daughter had medical expenses at the two hospitals she went to totaling approximately $41,000. You understand that we were able to reach an agreement with the hospital to reduce those bills to $7,500. Do you ask the court to approve payment to the hospitals that treated your daughter of $7,500?
Yes.
After all the deductions I just walked you through, you understand that $14,355.86 will be left for your daughter to purchase an annuity that has been explained to you, correct?
Yes.
You understand that that annuity will pay $1,894.18 semi-annually for 4 years, beginning when your daughter turns 18. You understand that?
Yes.
Are you asking the court to approve the purchase of that annuity with the settlement funds for your daughter?
Yes.
No one has forced you to enter into this settlement. You're doing it on your own free will, correct?
Yes.
And you are asking the court to approve this settlement as I've outlined it and talking with you here today, correct?
Yes.
Nothing further, Ms. Harris.
All right. Anyone else have any questions?
Your Honor, I'd like just to ask one question.
Okay.
Ms. Harris, you understand that the settlement that is going directly to your daughter, DH, you understand that this is for her benefit and that you are not entitled to these monies. Is that correct?
Yes.
Okay, no further questions. Thank you.
Okay. Anyone else?
Yes, I have just a few questions.
Okay.
Ms. Harris, you and I have spoken on the telephone a time or two and have also met in a Zoom conference. Is that correct?
Yes.
Okay. And I explained to you that because your daughter is under the age of 18, that in order for her settlement to be what I'd call a rock solid, valid settlement, it requires court approval. Do you recall that conversation?
Yes.
Okay. And I explained that it was not my job to redo everything that Mr. Bollinger has done, but my job was to step in and take a look and evaluate the settlement strictly on behalf of your daughter. Do you recall that?
Yes.
Okay.
Yes, I do.
And we also discussed how to invest the balance of the settlement on behalf of your daughter. Do you recall that?
Yes.
Okay. And essentially, I explained that if the money is deposited with Dallas County, that she would receive one lump sum when she turns 18. And we discussed as an alternative to purchase an annuity, which would spread out the payments. Do you recall that?
Yes.
And you were provided 2 different plans for the investment of the annuity, and you selected the one that we referred to as Plan 1, and Mr. Bollinger already laid out those terms in your previous testimony. Is that correct?
Yes.
Okay.
Yes.
Do you understand my role in the case?
Yes, I do.
Do you believe I have acted in the best interest of your daughter?
Yes.
Are you asking the court to approve the settlement as presented?
Yes.
Pass witness.
All right, Ms. Harris, do you have any questions for me?
No, I don't.
Okay. And do you feel this settlement is in your child's best interest?
Yes, I do.
And I may have missed this, but what attorney's fees are being awarded in this case for the plaintiff's attorney? I know it's reduced.
7,500 from
Okay,
10,000 to 7,500.
So you have 7,500 goes to the essentially goes to the hospital. 7,500 goes to you, and a little less than 15,000 goes to the minor. Is this kind of how it's broken down?
Correct. There's $664, I believe, in case expenses is the only element that you didn't summarize, but otherwise, yes.
Okay. And as I understand it, is there an agreement, is it Miss Style? Is that how you say your name, Style?
Yeah.
Ms. Stiles, is there an agreement as to the amount of the guardian ad litem fees of $3,000?
Yes, there is, Your Honor.
Okay, great. Is there a recommendation from the guardian ad litem?
Yes, Your Honor. Briefly offer my report. I received notice of my appointment in April of this year and obtained the file materials from Mr. Bollinger. And of note in this case, one of the first things that is always evaluated, this was policy limit settlement. Additionally, then I look hard at how that is being divided. And the medical lien was approximately $27,000, and we were able to get that reduced to $7,500. Additionally, Mr. Bollinger graciously reduced his fee to 25%. Additionally, I reviewed his expenses, and they were all customary and specific. I do not approve those just line item fees of sometimes just general case expenses or anything like that. These were all very specific. I believe that an annuity, considering it's almost $15,000, it would be is in the minor's best interest as opposed to getting that one lump sum. Dirk Weeks presented us with a good alternative that I still think makes sense for the minor. Sometimes it doesn't always, because the cost of the annuity cannot be offset by the growth. But in this instance, I think it can be. And I believe and I've met with Ms. Harris and her daughter via Zoom. And they have both confirmed, and her medical records likewise confirm that she's had a good recovery. And so I am recommending the settlement be approved as presented to the court.
Okay, the court will approve the settlement as recommended by the guardian ad litem. Ms. Harris, I wish you the very best of luck. How's your child doing now?
She's fine. She's getting better.
She's doing better. Is she there with you, or?
Yeah, she's right here.
Well, let's say hi to her. Hi.
Don't do that.
My daughter would do something like that. That's funny. Nice to meet you.
Just say hello.
Hello.
This is a bad phone.
I don't have the best phone. Just say hello.
Did she say this is a bad phone? That's exactly what my kids would say.
She's complaining about my phone. It's not high quality. But I don't use the phone often, so stop that.
How are you feeling these days? Do you feel okay? Okay. Well, this is not going anywhere. All right. All right, Ms. Harris, the court is going to approve the settlement for you and your daughter. And I wish you the very best of luck. Ms. Meeks, I'm going to go ahead and approve the guardian ad litem fees to be paid by the defendant in this case. And I wish you guys the very best of luck, Ms. Harris. And Ms. Meeks, again, thank you for your service. And you guys are excused. Be safe, okay?
Thank you,
Thank you, Your Honor.
Thank you.
Thank you. Wait, is there a Laura Lewis on this case?
Pardon me?
A
Not
Laura
that- no.
Lewis or an Andy Bonilla? Okay. Thank you, guys.
Thank you.
Thank you.
Thank you, Ms. Harris.
Good to see everyone.
Good to see you.
I hang up. I mean,
All right. We had a Mr. Little and a Miss Lewis join us. What case are you guys here on?
Judge, this is Mr. Little. I'm here on the structured settlement transfer.
Miss Lewis, what are you here for?
I'm here for the 10 o'clock temporary injunction hearing for LaForce versus Adam Morgan. I represent defendant Adam Morgan.
Okay. So yeah, we're not quite there yet. And Mr. Little is I assume the gentleman or the person who wants to sell their annuity is going to show up at some point.
His name is Bonilla. Let me look at the participants, Judge. Um,
Oh, I thought I saw someone named Bonilla trying to sign on.
and Judge, I'm representing the annuitant as IPA. I think Christine Henniger is representing the factoring company.
Okay.
I don't see her when I pulled up the participants.
Yeah, it's still early. It's okay.
I think we were on at 9:30 was the time given to me.
Oh, I have 9:45, so you're early according to.
Okay.
It's okay either way. I can start whenever. Is it possible? So we did give people the option today of showing up in person. Is it possible that maybe your client's going to be, or not your client, the other folks in this case are going to show up in person?
I guess it's possible, Judge. I haven't really spoken to her. I've only spoken to my client.
Okay.
I guess we just wait until she shows up. Either way.
There's Rachel Johnson showing up. Is that in this case or?
No, it's the annuitant is Andy Bonilla.
Okay.
Your Honor, Rachel Johnson's with me.
On the LaForce case, correct?
Yes, sir.
Okay, Ms. Renninger, what are you here for, ma'am?
Hi, Judge. I'm here on the structured settlement that's at 9:45, so I'm just a little bit early.
You're early.
Yeah, and I believe that the annuitant is on. Oh, and James Little is also here. He's the annuitant's attorney.
All right, so while we're doing this, why don't you kind of give me the breakdown of the settlement or what you're trying to sell and all those details?
Sure. Mr. Bonilla is the annuitant. He is selling one annual payment of 20. Do you want them broken down like each payment or just the totals?
Each payment.
One payment of $25,000 due on January 1st, 2022. 240 monthly payments each in the amount of $2,920 starting February 10th, 2024, continuing through January 10th, 2044, increasing 3% annually. So the aggregate is $966,537.88. The discounted present value is $847,451.44. And my client will pay him a lump sum of $475,000, which is the 5% effective interest rate.
Wow, that may be the biggest one I've ever seen anyone try to sell. Okay, that's. I'll just say this: I hope there's a really, really good reason he's doing this, because I don't foresee I would approve this settlement, but I don't know the details. So, at first blush, it seemed like something I would approve, but I'll hear, of course, from everyone. Mr. Little, did you already submit the required affidavit? Let me look at the file. Let me see if you've submitted that already.
I did not submit an affidavit, Your Honor.
Okay. This court requires in advance of the hearing that certain questions be answered. It's all on our website. So we may not be able to do this today anyway if I don't have that. Okay. Yeah, I don't see that that's been filed.
I'm sorry, Judge, I wasn't aware of the affidavit. I've been doing this for 21 years. I've never had to submit an affidavit. Where on your website is this form?
I'll
I'm
go
actually
ahead. I'll go ahead and pull it up just a second.
I'm on your website now.
On the county website?
I'm actually at 68 District Court.
Let's see.
It's under standard orders, David. It's on the, I just found it. Standard orders, if you click on that, then it says approved transfer of structured settlement payments. I didn't know about this either, or would have let you know. Sorry.
Yeah, I'll go ahead and share screen it if that's helpful. We've been doing this for about 2 years, yeah, almost 2 years. Wait, is it shared right now? I can't tell. Okay, let me share screen.
I found the affidavit, Your Honor. Or actually the standing order, not the
standing
affidavit.
order. Sorry, yeah, that standing. It requires you to provide a written disclosure. Okay, all right. Is Mr. Bonilla here?
Yes, sir. How are you doing?
Good, 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 good. All right. The court has a standing order on a motion to approve transfer of structured settlement payments and requires that certain disclosures are made at least 5 days before the hearing, and that hasn't been done, so I won't be able to approve this today. But I'm glad to kind of talk with you guys about this and kind of figure out, this is the largest, I think, that I can remember. Been doing this for 15 years, the largest transfer I've ever seen or proposed transfer. So just wanted to kind of get just a general feeling of why this would be a good idea. Mr. Bonilla, why don't you kind of talk to me about why you want to do this?
Well, I mean, I've been speaking to Logan from Liberty. He's the one that helped me out with all this. I mean, I basically told him the same thing I'm about to tell you, that I just want to work in properties and real estate. I took a real estate class right after high school. And I mean, it was interesting to be a real estate agent, but I personally like to be on hands. I can't.
Are you a real estate agent now?
No, sir.
Okay.
Like I said, I personally want to be on hands. I was thinking, I looked more into flipping homes. And
have you ever done this before? Have you ever flipped homes?
No, sir.
Okay.
But I have been looking into it, and it just catches more of my attention. I recently, well, actually last year I started working on remodeling homes, like the floor, and it really got my attention. I actually have like a passion for it. It might seem like a lot of work, but it fulfills me. And to purchase a home and me personally fix it up, me being on hands, it's something I really want to do. I watch a lot of those TV shows of those brothers that flip homes, and that's honestly what I would.
My wife does that too. She watches those all the time.
It's like creating art. You're getting a home that has been like worn down, and for you to come in and just paint it to something beautiful and make another family happy. It's just, I mean, it's kind of what my mom does. Instead, she does curtains and draperies. She has her own business, and every time the customers give her that smile, that happy feeling of, wow, look what you just did to our home. You made it beautiful.
Mr. Bonilla, can I ask, how old are you? How old are you?
22.
22, wow, okay. Is Glenn Rush on this case? No, okay. Well, Mr. Bodine, let me kind of talk to you. We're not going to be able to do anything today because there wasn't the mandatory disclosure done, but let me kind of talk to you about what my role is so that you kind of have an understanding of why I'm here and what we're doing and kind of what's going on. So the legislature many years ago made the determination that judges like myself are put into kind of a difficult role. I will say that this is not necessarily my favorite thing to do, but I consider it a very important thing that I do. And I have to make a determination that in the sale of these types of sales where annuities are being sold, that is in the best interest of the person who wants to sell their annuity. So this was created by a court, and the sale has to be approved by a court. I have a lot of times where people come in and they want to sell their annuities, and it would be a lot easier for me to be able to just say, do whatever you want. I don't care. It's your money. Probably people would be happier with me if I did that. But just like you have a job, what do you do for a living right now?
I help my mom with her business, and
Okay.
I work in the stock market.
You work in the stock market? What do you do for the stock market?
No, I mean, I don't work for it. I work in it. I'm sorry about that. Like I just day trade or swing trade now and then.
So when you're working for your mom, you have to, you have certain responsibilities that you have to do, and you do them to the best of your ability, right?
Yes, sir.
And I will tell you that part of my job is to make sure that these types of sales are in the person's long-term best interest. And so I take that very, very seriously. This transaction does not seem to kind of fit within the criteria of what I've approved in the past. I do want to be able to get the disclosure that's required to be able to see if there's more to it. But, it's a tough thing because I know you hired an attorney, that you want to do this. It sounds like you do have a passion, but you have no experience with doing this. And so right now you have guaranteed money that's almost $1 million that you're wanting to sell for half of that. And that's a major concern. And so I just want to kind of explain to you what my role is and why I do the things I do and why I do it the way I do it, because you're probably going to leave this. And I had one guy yell at me because I didn't approve his settlement, and he ran out of the courtroom and said, we need to run someone against that judge because he was really mad. And trust me, my job would be easier if I just rubber stamped every one of these. But just like you have a job to do where you work and doing the best that you can do and living up to all of your responsibilities, this is one of my responsibilities as a judge, to make sure that these settlements are done in the best interest of the people who are involved. And the reason I think the legislature has done this is that there has been a history, at least from what I've read from the legislative history and what I've seen, where sometimes companies will try to take advantage of people. I'm not saying that that's necessarily the situation here, and try to do something that's really not in their best interest. This is guaranteed money. It's guaranteed as any money that's out there. I remember when we had the foreclosure crisis and people were worried that banks were going to fail, and a lot of banks did fail, but not a single annuity that I'm aware of failed. And so even in the worst of economic times, this is a safe investment. And what you're proposing to do is something that is extraordinarily risky, especially considering you've never done it before. You're not licensed. So one thing I'd urge you to think about it before the next hearing is maybe wait to do this, get some experience with flipping homes, maybe get your real estate license, and then maybe come back in a year or 2 years or 3 years. Trust me, there'll be companies that want to do this deal. It's an extremely favorable deal for the other side, and maybe wait to see if maybe this is money that you could really use, and maybe this isn't in your best interest. And does that make sense, Mr. Bonilla?
Yes, sir. I actually been looking into how to to see how much I would be making if I was to buy a duplex. And I found one in Arlington for $375. The monthly income would be $3,200, I believe. And from now till 15 years, how I'd be making way more than what the annuity was gonna be giving me. So with the appreciation of the house plus the 15 years of renting it out, it would be.
And that's part of what we want in the disclosure. None of that's been submitted. We don't have any paperwork on it. We don't have any documentation. And so if you want to submit that type of information and the proof you have on it, that would be great things to look at. It's just, I don't have any of that right now. And I have to, just like you have to do your job and make sure that I have to make sure that I look at documentation and proof and evidence before especially on an annuity sale like this. And so that would be good information to get to your attorney. If you decide you want to go forward, if you decide you don't want to go forward, that's okay too. And you can dismiss this case, and I will make sure that no one tries to request attorney's fees against you in this case. But if you do want to try to go forward, and I would not recommend it, but if you do, seeing that type of proof would be really helpful.
Okay, sounds good.
All right. Do you have any other questions, Mr. Bonilla?
No, sir.
Mr. Little, did you have any questions?
No, Your Honor, if we get that form to you, how soon could we get this reset?
Probably a month, I would guess.
A month? Okay. All right, we'll contact the clerk to reset it once we have the affidavit submitted.
Okay. Did you have any other questions? Who's the other attorney on this? Ms. Henniger? Rediger, I'm sorry, Ms. Rediger, I apologize. I know I'm Ms. Henniger too. Did you have any questions? I think you've been in my court before.
No, I have no other questions.
Okay, great, guys. Well, you guys be safe. Mr. Bonilla, it was so nice to meet you, and really, really think about what I've said. I don't think this is in your best interest, but I will consider all of the evidence and take a look at this. And if I don't want you to get your hopes up. I think even if you give me the evidence that we've discussed, I'm probably not going to approve this particular transaction, given your age and your history with real estate. Just, I don't know that, I think I'd want to see some kind of track record, and I don't think that's going to happen, but I do want to, if you do want to submit it and you want me to hear it, I'd be glad to listen to it. So do you have any other questions, Mr. Bonilla?
No, sir. Thank you.
All right, thank you. All right, guys, you have a good day.
Thank you, Judge.
All right. Is anyone here on LaForce versus Adam Morgan? I think it's still a little bit early, but I think I've seen some of the folks who are here for that.
Yes, Your Honor. Caroline Harrison on behalf of LaForce. And I have my associate Spencer Manka with me as well.
Okay, so are you the plaintiff's attorney?
Yes, Your Honor.
I'm going to get this all kind of set up. And who's your associate?
Spencer Manka, M-A-I-N-K-A.
Is he on here? I think I saw him.
She is, yes.
I'm sorry, I apologize. And the defense attorney in this case is who?
It's Laura Lewis. I think I saw her on a second ago.
Miss Lewis, are you there? There you go. She was here early. Thank you. And Miss Lewis, do you have any other attorneys with you?
I do not have any other attorneys here with me today.
Okay. And then do we have any of the clients, any representatives of LaForce Entertainment here?
Yes, Your Honor. Glenn Roush is here.
Mr. Roush. Okay, we're going to put you right up here. All right. And do we have anyone representing the defendant?
Yes.
I'm sorry, not representing any of the, is Mr. Morgan is here?
Yes, we have.
So let me see who I don't know. The only person, Rachel Johnson, what are you here for?
We have witness Rachel Johnson and Keith Walters here on behalf of Adam Morgan.
Okay. And is there anyone else we're expecting? And that is optional for people to show up in person today? Are you guys sending anybody in person today?
We are not, Your Honor. For plaintiffs, we are not.
Okay. For the defendants, are you guys sending anybody in person here? No? Okay. are we expecting anybody else to show up? Because we are early. I'm going to take a quick 2-minute break. But are we expecting anyone else to show up?
Not from plaintiff's side, Your Honor.
Ms. Lewis? No? All right, give me 2 minutes and we'll restart, okay? Okay, everybody ready?
Yes, Your Honor.
Tony, are you ready?
Yes, Judge.
And just for the attorneys, these are interns that are here. You guys okay? Okay, sorry. All right, let's go on the record on cause number DC 216091, LaForce Entertainment versus Adam Morgan. Counsel, make your appearances.
Caroline Harrison and Spencer Manka on behalf of Plaintiff LaForce Entertainment.
Laura Canada Lewis with Canada Lewis and Associates on behalf of Adam Morgan.
Okay, we're here on a temporary injunction hearing. Let's go ahead and proceed. Ms. Harrison, you may start.
Thank you, Your Honor. Would you like to have an opening or would you prefer that I just go into the witnesses?
Yeah, well, I mean, just a brief opening. I know what the case is about. We had the temporary restraining order, but if you want to kind of give us an update of what's happened since then.
Sure, and I'll give you just a brief roadmap of what we're intending to show you today. Essentially, what we want to show the court is that Adam Morgan received valuable specialized training before he was allowed to perform any event production services. We're going to show the court what event production services are and distinguish those from just what you might think of as typical DJ services at a party. We're also going to explain how DJ personality training works and the amount of time that LaForce has put into training its DJs and developing the training program. We're going to show that the restrictive covenants were designed to protect the specialized training and confidential information that Mr. Morgan was given, and that it was specifically designed, the restrictive covenants are specifically designed to keep him from going to work for a competitor or starting a competing business after he received all of the training, and to protect the referral sources, which are one of the main ways that LaForce gets business. And we'll explain to the court why those referral sources are so important and worthy of protection. And we'll also explain how Mr. Morgan received confidential information about LaForce's strategic plans and strategies, and even participated in creating those and furthering those, and how Walters, the company he's now partnered with to form co-host, was his major referral source and his major account while at LaForce. And it was his job to further that relationship on behalf of LaForce. We'll also explain how the services offered by LaForce and Morgan while at LaForce, they weren't simply DJ services. There's a lot more that goes into that. And I know that that was an issue in the TRO hearing, so we're going to explain that better to the court today. So that is what we plan to do today. Our first witness is going to be Glenn Roush, and we would also like to invoke the rule.
Okay. What do you mean by, I understand, I know what invoking the rule is, but how do you want me to do that exactly?
Well, I know when I've had other TI hearings in other courts, not your honors court, the witnesses have either been put in a waiting room or they've been asked to come back. Counsel has gotten them to log back in at the time that they're called. I'm not sure how your honor handles that, or if you've handled it on a Zoom hearing before.
I haven't dealt with that. Is there so there's some witnesses here. I guess I can put them into a breakout room. That's fine. So who are the witnesses? Rachel Johnson and Keith Waters?
Walters, yes.
Walters, I apologize. Let me go ahead and set up a breakout room. So guys, are you familiar with Ms. Johnson and Mr. Walters? Are you familiar with breakout rooms and how that works on Zoom?
Yes, Your Honor.
Mr. Walters?
No, I've not done a breakout room.
So we're going to send you into a separate video room where you're going to be with Ms. Johnson. You're welcome to, anyway, you'll be in the room there. At some point, I will probably come and get you on the bottom right portion of the screen. So you're going to first sent an invitation to join the breakout room, accept that invitation. You'll go to the breakout room, and then when it's your turn to testify, I'll go into the breakout room, ask you to come out of the breakout room, and then on the bottom right corner of the screen, there'll be a way to leave the room and come back to this room. Does that make sense?
Yes, sir.
Okay, so just make sure you accept the invitation, and I'll go ahead and, it's just those two witnesses, correct?
That's my understanding, Your Honor.
Okay. Let's see. Keith Walters and Rachel Johnson. Okay. All right. Are you guys ready to call your first witness, Ms. Harrison?
Yes, Your Honor, I am.
And Ms. Johnson, you need to accept the invitation.
Did you?
Yeah, I did.
Ms. Johnson is still here, so we can't start.
Just 1 second. Her says she's joining and she's leaving. I've got to relocate her because she's physically in the same room as me. So we're
Oh, okay.
in the conference room. We just need a second to manage the logistics.
Sure, that's fine. While we're doing that, Ms. Lewis, can you hear us?
Yes, sir.
Go ahead and pre-admit as many exhibits as possible. Are the plaintiffs offering any exhibits?
Yes, Your Honor, we're offering exhibits 1 through 17, I believe. And they were emailed to Ms. Pinson yesterday and this morning.
And then Tony, did you get those exhibits?
I have not looked, Judge. Did you send them to TA Rager email as well?
No, we did not. I'm sorry. I'm happy to do that. And it's actually 1 through 18. My apologies.
Any objections to plaintiffs 1 through 18?
No, Your Honor.
Plaintiffs exhibits 1 through 18 are admitted. Any defendants exhibits?
Yes, Your Honor. We submitted exhibits 1 through 13 yesterday morning.
Did you submit those to both Ms. Pinson and Ms. Rieger?
We submitted them to Ms. Pinson, who said she was sending them to Ms. Rager, but we can resend them.
That's fine if that's what she said. So any objections to, you said 1 through 13, is that correct?
Yes, sir.
Any objection to defendants exhibits 1 through 13 are admitted without objection. All right, call your first witness, Ms. Harrison.
All right, plaintiffs call Glenn Roush.
Mr. Roush, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You may proceed.
All right, Mr. Roush, will you please introduce yourself to the court? Tell us your name and what you do for a living.
My name is Glenn Allen Roush Jr., and I'm the managing partner at LaForce Entertainment, LaForce Event Group.
What does LaForce Entertainment do?
We do a lot of things, but primarily our business revolves around providing wedding and wedding production and entertainment.
Okay. And what is wedding production and entertainment? How would you describe that a little bit more for the court?
So more specifically than just what people think of probably as a DJ that stands behind a turntable and just plays music for a group. Producing a wedding is really involved with narrating, directing, scripting, moving the guests from just the actual ceremony all the way through, in a wedding, there's typically anywhere between 5 and 10 formalities, as well as getting them all the way to the party and the celebration. And so the DJ and the MC is going to structure the event, work with the clients, set the stage, make sure that everyone's in the right place at the right time, prepping whoever's going to be speaking on the microphone, that they're about to be on stage, but on the dance floor, about to hold a microphone and be talking to guests.
How long have you been in this line of work?
Approximately 21 years.
How long have you had LaForce Entertainment?
11 years.
How do you know Adam Morgan?
I met Adam Morgan when he began working for me in the first quarter of 2016.
When he started working for LaForce, did he have any prior DJ or event production experience?
To my knowledge, no.
What was Adam's role when he was hired?
When Adam was hired, he came on as a DJ apprentice, DJ assistant. He expressed an interest to become a DJ with our team. And so he went through our training and development program and was promoted up to becoming a DJ.
Did he eventually take on any other roles within LaForce Entertainment?
He did. Adam moved up fairly quickly within about a year and a half. He started doing sales for us and then moved up into business and relationship development.
So we'll talk about in just a minute what it means to be a LaForce DJ or event production personality. But let me ask you first just a little bit about what you just said, that he moved up and he started doing some business development and sales. Give me an idea of what it was he was doing for you in that role.
So initially he he excelled with making contacts. He excelled with doing like open houses, which is venues will set up their ballroom designed for like an event and invite vendors to come in and talk to the clients that are either already scheduled to be at their venue or looking at being at their venue. And he and I connected really well with similar personalities. And so I started working with him, and he began eventually talking to other wedding planners, helping me form a plan for what venues we were going to approach, how we were going to come on the preferred vendors list, become a trusted partner in their open houses and the systems of what they were doing. And then that led to him being in Austin for a time while we were working to open an office down there, as well as overseeing continued account development in Dallas-Fort Worth.
So it sounds to me like what you're saying is he might have had some role in the strategic planning. Is that fair to say?
Yes, ma'am. He was definitely part of the strategic planning and on my leadership team.
And how often would you have discussions with him about strategic planning?
It really varied depending on our schedules because our work is very seasonal. But typically anywhere from once or twice a week. Some weeks we were a little bit busier, and it may have been 2 to 3 times a month with him and I directly interfacing. But yeah, I would say once a week on average.
Did you and Mr. Morgan also have discussions about pricing events?
Yes, we did. We discussed pricing strategies, different strategies for different venues.
Did you also have discussions about profit percentages and profit margins?
We had some discussions about the profit margins and the overall percentages, but at the time we were really working together, growing the businesses. We weren't so locked in on squeezing out 11% versus 10% as we were how we were going to grow market share and grow our ability to support our growing team of DJs.
Did you consider this information that you were discussing with Mr. Morgan to be confidential information to LaForce?
Absolutely.
Was he responsible also for developing referral sources?
He was.
Can you explain to the court why it is that referral sources are so important to the way that LaForce markets itself?
Absolutely. So a lot of people in the event industry look at our business as very much a B2C, business to consumer, and there is a level of business to consumer with what we do, but there's also a massive part of business to business development because so many of the venues, catering managers, wedding planners, photographers can be a really good source of business because they can actually more than just looking at a website. What we do on music and performance and entertainment doesn't always translate in photos or on a website, and so it's really valuable to have someone that can testify to how well the team is doing, how well the DJ is doing, performing at an event, keeping the party moving, keeping all the guests happy, keeping the clients excited. And so we really have to focus on the B2B aspect of our relationship so that we can continue to get the best events in the market.
And when you say B2B, you mean those referral sources, is that right?
Yes, ma'am. Sorry. I mean, wedding planners, other businesses that service weddings.
How much of your business would you say on a percentage wise comes from B2B referral sources?
50 to 60%.
Did you introduce Mr. Morgan to referral sources?
I did.
Why would you do that?
So I have an approach with my team I want the DJs to be known amongst the market. It's part of my coaching to help them get the best dollar for actual performing at any event. My business is structured not so that we're booking a DJ for a set number of hours. We're actually trying to develop talent, a DJ to become talent and be able to book for the top dollar, with the idea being that we can make DJing a full-time job and a sustainable living.
And when you introduced him to those referral sources and then had him interacting with them, did you expect that he was going to be using LaForce's goodwill to enhance LaForce's business?
Absolutely. I mean, I think the understanding from the very beginning was that he was going to be able to use LaForce's goodwill to develop his own book of events, his own schedule of events to fill his calendar, and then it grew from there.
Is working with referral sources post-employment, is that something that LaForce seeks to restrict in the non-compete agreement?
Yes, ma'am.
Why is that?
Because if every employee that I introduced to one of our business sources was just going to be able to leave and take them away, it would create a situation where I wouldn't be motivated to develop talent or entertainers because I would just be stripped of my business for all of my hard work.
Getting back to Mr. Morgan's role on your team, did you send him to conferences and industry events to market?
I did. Yes, ma'am, I did.
What types of events would you send him to?
A lot of local events. So in the event industry, there are a number of educational groups that meet. Some of them meet for lunchtime, some of them meet in the evening for cocktails and dinner. But there are about 5 groups that we kind of really do a lot of work with. And so I would send him to local networking groups. I would send him to open houses for the various venues. We also did open houses, like I said, in Austin. And I sent him to conferences in Las Vegas, Chicago, a number of other places where he could do personal development and business development.
And were those trips that LaForce paid for?
Yes, ma'am.
Did you also send him to something called DJ Think Tank?
Yes, ma'am.
Can you tell us what DJ Think Tank is?
DJ Think Tank is a 503c6 organization that I'm actually on the board of directors for. It is a group of 45 DJs, primarily from the United States, but there are 2 international members. And it's a group of DJs like myself and Adam that are trying to make a full-time living out of what we do. And it's a group of DJs that get together with the idea that we're going to be able to share openly with each other without the idea that we're going to be competing in the same market with the same ideas.
Is there some requirement that people that go to DJ Think Tank have a level of an expectation of confidentiality when they're in that group?
Yes, ma'am. We have something that's called WIT, which is WHITT. It means what happens in think tank, and it means what happens in think tank stays in think tank. And by that, it means that when we talk about something, when we discuss something, if, for example, if one of my cohorts from New York shares with me a new photo booth that he's developed and found and wants to give me the opportunity to also bring it into my market, the idea is that I'm not going to share it with somebody that's in another market. I'm not going to claim it as my own as well. The idea being that I'm not going to infringe on his ability to have a head start on launching it in his own market.
Did you personally consider this information to be confidential, something that you had to safeguard and keep confidential?
Yes, ma'am.
And was Mr. Morgan aware of the requirement to keep DJ Think Tank information confidential?
Yes, ma'am. All the members of my leadership team, and even most of my DJs that have gotten to meet the traveling DJs that have come into town, we have really deep discussions about the idea of the information that we are allowed to share and not allowed to share, and that we're protecting ourselves and protecting each other.
When did Mr. Morgan become more a part of your leadership team as opposed to just doing event production work?
Approximately second quarter of 2017.
Okay. Did he receive any additional pay when he started taking on these additional duties?
He did. So he was being compensated as a DJ for the events that he was working. And then he was being compensated for a variety of things on a full-time basis.
So was this his full-time job then, working for the force?
Yes, ma'am.
In his last full year, that would have been 2019. Do you recall what he made?
Approximately 91,000, I believe.
Okay. I'm going to show you exhibit what has been marked as Exhibit 1. Your Honor, I don't have the ability to
Let me go ahead and enable that.
Thank you.
Okay.
Mr. Roush, do you see Exhibit 1? I'm gonna scroll through it so you can take a look and tell me. Do you recognize this document?
Yes, ma'am. This is an email between Mr. Morgan and myself.
Okay, and this has already been admitted as Exhibit 1. Can you tell me what it is that you were discussing in this email?
Absolutely. So Adam, through the course of doing business development, had determined that somebody that we knew from working at Walter's Wedding Estate venue, Milestone Denton as it's listed, had started as the manager at a new venue. And they were approaching us about being on their preferred vendor list. They were, as you see there, they were offering the terms that they want. Typically, venues will ask us to pay a fee to them to help support their marketing efforts. And in return, they help us with letting us be at their venues. They let us put additional promotional and marketing material at their venue.
So was this the kind of thing that Mr. Morgan would regularly be doing in his role in business development for you?
Yes, ma'am.
All right. I'd like to turn now to Mr. Morgan's role as a DJ. We've talked about his role in business development and leadership. Let's talk about his role as a DJ. Did Mr. Morgan have to train with LaForce before he was allowed to go out and do event production services?
He did.
Did he help us understand what that training program is? And to do that, I want to ask you some questions about first of all, what makes a LaForce wedding different from, say, going to a club and hearing a DJ play, or going to a party and hearing a DJ?
Absolutely. So if you're going to a public event, a club, a bar, a party, and you're listening to a DJ play, typically they're getting to pick the entire playlist of what they're going to play, or they're given some parameters about this club is this type of club and we target these type of clientele. We want this type of music played. It's very structured, very strict usually. And the DJ probably does not speak on a microphone other than maybe to announce last call and tell people to get out. Versus on the event side, we're playing for typically a crowd that is age ranging from 8 to 80 years old. Normally on average 150 to 200 people. And we're playing a specific party list that is designed around the couple, the bride and grooms, their taste in what they want for their celebration.
And in order to get to that point where you have DJs performing in this way that is sort of your LaForce signature, do you have a structured training that you put them through?
Yes, ma'am. We have a DJ school and an MC school.
How long is DJ school?
6 weeks.
And is it once a week? Is it, a couple hours a week? How long?
Yeah, sorry. It's typically once a week. It's typically once a week for it's listed as 2 hours, but they usually end up going 2.5 to 3 hours.
And after they're done with DJ school, do you automatically start putting them out to work events?
We may put them on something that is a small party where they're not going to have to talk on the microphone yet. But typically, no, we're not putting them on events until they've finished MC training and been able to shadow a trained DJ for a period of time.
What is MC training? Is that different than DJ school?
Yes, ma'am. So DJ school is really to help them understand first the core of beat mixing, beat matching, which is making one song sound like as you're transitioning to another song as though the songs never end. They're just overlapped and connected. So that's the DJing portion is really, well, that's the start of the DJing portion before we get into the actual playlist of what to play and when to play it. But then the MC school is helping people understand what to say, how to deliver key lines, how to deliver an applause line, which is it sounds like an odd thing for people in law to understand, but in the entertainment performance industry, you have to know how to deliver an applause line so that you get the reaction you want. Otherwise, people just sit there and look at you like crickets.
Okay. Once somebody's done with DJ school and then MC school or MC training, what do they do then? Is there some kind of final exam?
Yeah, so on both sections, there will be an exam where they show mastery of the DJ portion, and then mastery when they finish MC school, they'll show mastery of both. And what I mean by that is we would assign them a wedding that was either a fictional wedding or a wedding that had been previously done with all the formalities from our planning forms, and they would have to put structure to it, and essentially without guests there, without 200 people there, but with my leadership team sitting in attendance, taking notes, giving grades, that DJ MC will have to perform and show a mastery of both skills.
Once they pass that final.
Harrison, just 1 second. This was only scheduled for 30 minutes. Are we going to be able to finish this in 30 minutes?
We're not, Your Honor. We had asked your clerk for 2 to 3 hours, and we're told that we were only allowed to have 30 minutes. So I was trying to get out the most important points from Mr. Roush today in my 30 minutes.
I mean, it's 30 minutes total though, right?
Yes, Your Honor, I understand that. When I talked to the clerk about it, or when my assistant talked to the clerk about it, she said we were going to have to bring that up with you if we didn't finish in 30 minutes.
Ms. Lewis, are you going to need to present any evidence?
Absolutely, Your Honor. They're trying to prevent my client from working. We absolutely have to be able to defend this.
Okay, I'm not fussing with you. I'm just asking.
I'm sorry,
So,
I'm stressed about it.
Well, because the next hearing is already showing up.
We're happy to be reset with Your Honor at Your Honor's convenience. We would, of course, ask that the temporary restraining order be extended until.
All the stuff you're kind of talking about it. Is there a way to speed it up a little bit, or?
I can speed it up some, but I do not believe that we will finish in 30 minutes or in 6 more minutes, Your Honor.
If we gave you an hour, could we get this finished, do you think, guys? If I give you another 6 minutes and then the other side has time?
Your Honor, if we have 30 minutes, we can probably do ours in 30 minutes, but not in the time left.
Ms. Harrison, can you finish it with Mr. Rush in the next 6 minutes?
I probably need 15 minutes to finish Mr. Roush, Your Honor.
Well, I mean, the other option we have is under the emergency order, we just do this via affidavit. I don't know that we want to do that. Ms. Lewis, what is your thoughts?
Your Honor, I don't know. I feel like my client is really at a disadvantage. Mr. Rush has gotten to speak to the court. My client hasn't gotten that opportunity. And I think the real crux of our issue here is that Mr. Rush thinks a wedding venue is competing with him and that somehow he has a right to perform services in someone else's business that he doesn't have. And I don't know how we get there from here without some conversation and some true testimony that you get to hear from the owner of this venue. The owner of the venue is not going to let Mr. Rush steal this employment opportunity. It seems unfortunate that he doesn't like his job and he wants to take this other job, but it's not open to him.
Your Honor, that is not.
Whoa. So we're not getting into argument right now. So what we're going to do is I have 2 other hearings this morning and I have to leave here by noon. So the other 2 hearings I anticipate will be pretty short. I think Mr. Link is already here. If I saw him, I thought he signed on, maybe not.
Yes, Your Honor.
There he is in the bottom. I anticipate his hearing will be pretty short and probably the 11 o'clock will be short. So I'll just kind of, fit them in when their hearings are and we'll get as much done as we can today. Ms. Harrison, I would just urge you to try to speed up just because if I can't get this finished today, I don't anticipate Ms. Lewis would agree to an extension. So you may want to try to hurry up a little bit.
Understood, Your Honor. Thank you.
Let's proceed.
Mr. Roush, can you, once a DJ is done with DJ school and MC training, is there still another part of your program or do they get to start doing weddings? I believe I asked you that question already and you were in the middle of answering it.
Yeah, so once they complete DJ and MC school, they will continue to shadow another DJ or multiple DJs to get ideas for their own performance at events, as well as learn just tips and tricks on what to play, when to play it, and really just getting an experience for live events because it's so different from anything else anyone typically does in their work career.
And did Mr. Morgan go through DJ and MC school with you?
He did.
And did he then have a time where he was apprenticing and shadowing other DJs?
He did.
Once he started working for you full-time, did he also have DJs under him that were apprenticing that he was training?
Not immediately, but yes, he did eventually become a developer and started training DJs as well.
How long did it take you to develop DJ school?
Approximately 4 years.
Okay, do you have training materials that you have at DJ school?
We do.
I'm going to show you what has been pre-marked as and admitted as Exhibit 3. And can you tell me just briefly what this is?
Yes, and this is the syllabus, just the syllabus that the DJs get on the first day of DJ school.
And is this representative of the kinds of things that you train for in the 6-week period?
It is.
How many events does a typical DJ have to go through before they're allowed to do event production services on their own?
Typically 40 to 50.
Okay. I'm going to show you now what's been pre-marked and admitted as Exhibit 4. Can you tell us what this is?
This is a report of all the events that Mr. Morgan did while working at LaForce.
And if we scroll down this, it looks like it's 10 pages. That looks like quite a lot of events that Mr. Morgan did over the years.
Yes, ma'am.
Where did you get this document? How did you create
I
it?
export. We've got a software called djeventplanner.com that I was able to export this from.
What types of information is contained in DJ Event Planner?
Wow, it handles both our CRM, so all of our information about our clients, whether they're corporate or individuals for a wedding, where the venue are, details about the venue, sales price, options chosen, compensation. There's a lot of information within it.
Do you consider other than the report I just showed you, do you consider some of the information in DJ Planner to be confidential?
I do consider some of the information to be confidential, yes.
What types of information in the program are confidential?
The information is going to pertain to within our system you can track how many events that we had for a specific venue, a specific entertainer, how many leads that we received for a specific venue from a specific wedding planner, how many of those we booked. There's a whole cache of information because we do approximately 2,000 events a year.
Okay. Does it also have financial information about LaForce in that program?
It does, yes.
Does everyone at LaForce have access to that information?
No, ma'am.
Can just any one of your DJs see all of the information in the program?
No, ma'am.
Is the program restricted by passwords?
It is restricted by passwords, and then there are different access levels set by type of user. Think admin, staff assistant, DJ, admin, sales administrator. There are various roles that can limit the access to different information.
Is there a level of access to the program that is given to people who have signed confidentiality and non-compete agreements only?
Yes.
Did Adam have access to the confidential information in the program?
He did.
Was there anything that Adam Morgan was restricted from seeing in the program?
In the program, no.
Okay, guys, we're gonna have to take a quick break and go to the other hearing. Are both sides here on the Swindle versus 1 and 2 automotive case?
Plaintiff is here, Your Honor.
Mr. Smith, are you there? I thought he was connected. I'm sorry. All right, is that your opposing side for this, Mr. Link?
Your Honor, the opposing counsel withdrew, and I'm not aware of any counsel that has subbed in for the defendant.
He's for the 11 o'clock hearing. So go ahead and make your argument on the continuance.
Well, Your Honor, the opposing counsel is withdrawn. My understanding is that this defendant business is now out of business, but it is an LLC, so it cannot be pro se. I've filed a motion for summary judgment, which I think the most expedient way to resolve this case. I've not been able to get in contact with the defendant, so I don't know what their plans are, but they did not show up when they were properly noticed to a deposition. Again, I think the court could decide the case on the merits with a motion for summary judgment. That's why I filed the motion for continuance, just to allow enough time to set the motion for summary judgment for a hearing, as opposed to remaining on the court's trial docket and then not having the defendant show up and potentially.
Is this going to be is this on the jury trial docket?
It is, Your Honor. The defendant paid the fee before the counsel withdrew.
Okay.
And that was my concern of showing up and wasting the court's jury day when the defendant doesn't show up and the plaintiff waives the jury.
Okay, that sounds good. Have you tried to get the summary judgment set yet?
No, Your Honor, my understanding is that I couldn't get it set because of that trial date was so
Okay.
close. So I needed to push the trial date back, and then we can get it set right away.
Okay. All right, we will, how about we reset this to, how does August 17th sound? Will give you enough time?
Yes, sir, Your Honor. We'll contact the court and get that MSJ set at the first available setting, and should be off the court's docket before then.
Okay. All right, give me 1 second. Can you go see, Alexa, can you go see, I just printed out an order. Can you go grab it for me? A minute. Actually, Audrey, I printed out 2 orders. Can you go grab the other one? Told her 1, I printed out 2. There's actually 2. Is that both of them or just the first one?
This is one. I'll grab the other.
Okay, here we go. Okay. All right, can you take these back to, I'm sorry, can you take these back to? Yeah. Okay, Mr. Link, that's it. Sorry, it took us a second to get the order signed. We're having some computer issues here. So you guys be safe. Anything else today, Mr. Link?
Nothing from the plaintiff, Your Honor.
All right, just try to get that set as soon as possible, and we'll go from there.
We'll do it right away. Thank you very much.
You.
May I be excused?
You may. Ms. Harrison, you may proceed.
Thank you, Your Honor. Mr. Roush, does everyone who goes through DJ training have to sign a confidentiality and non-compete agreement?
Yes.
Does every LaForce employee receive that training?
No.
I want to I'm going to show you Exhibit 15, which has already been admitted. This is Mr. Morgan's employment agreement, and I want to specifically direct you to the language that's highlighted. And I want to ask you to read little I, which is part of what Mr. Morgan has agreed that he would not do after he left your employment. Will you read that highlighted language, please?
Provide or attempt to provide or advise others of the opportunity to provide event production services to the benefit of any referral source with whom the employee interacted or about whom employee became aware of as a result of work performed in any capacity for the benefit of employer during the time employee was employed by employer.
So this specifically restriction from working from referral sources, as I read it, why are you so concerned about having him work for a referral source after he leaves your employment?
Because the the venues would, just like I'm having to deal with in this current situation, the venues would try to take the systems, the hard work that I've spent years building, and just try to replicate it at their own space.
Is that your understanding of what Walters is doing through co-host right now?
Yes, ma'am.
And why is it, let me have you also read section 2 here. I don't have it highlighted, but this is, will you read section 2, please?
Provide event production services in any location that is located within the following Texas counties: Tarrant, Collin, Denton, and Dallas.
And why did you say here provide event production services as opposed to DJ services?
Because when I talked with my counsel, when we were putting this together, we felt that entertainment was also going to be a part of the event production services, and the event production services really kind of covers the scope of the business that we have, because we do staging, lighting production, audio visual. We have a number of different divisions that we do for any given event. And with that, I try to, part of being on my leadership team and part of giving my DJs an opportunity to grow is giving them an ability to sell event productions on their events, so that we can create full-time jobs.
And did Mr. Morgan do event production services, or did he just do DJing services?
No, he did some event production services as well as DJing.
And why did you pick Tarrant, Collin, Denton, and Dallas counties as the restricted areas? Because
those are the 4 counties that I primarily operate in, and they seemed the most reasonable to request that I have some sort of exclusion over for a short period of time.
Now, why is it that you think that Mr. Morgan is violating this provision by competing and working with Co-Host Entertainment?
So the Ms. Lewis mentioned that the Walter Wedding Estates wants to testify about that the venues can have anybody work at their venues that they want, and I understand that, but the challenge here is that the venue hired away one of my employees for the strict reason of, obviously breaking what was outlined in my covenant. They want to cut my company just completely out of the mix after seeing the success and what we were doing.
So is it your understanding that Co-Host is actually providing DJ services at the event venues?
Yes.
I want to show you what has been marked as Exhibit 5 and ask you if you can tell me if you recognize this document.
Yes, this is from Co-Host's Instagram account.
And is this a picture of Mr. Morgan on their account?
Yes, ma'am. Outlining that he's the manager of Co-Host Entertainment. Lists him as partnering, but I'm unfamiliar with the actual structure of the deal.
I'm going to blow this up just a little bit. I'm sorry, it's a little bit hard to read. Can you read what this says about Co-Host Entertainment and Adam Morgan, just the first sentence here, please?
In the past 5 years, Adam Morgan has successfully led over 500 events as a DJ and event host. For the last 2 years, he has been voted favorite DJ by the American Association of Certified Wedding Planners.
Does this information that he's been in this industry for the past 5 years, does that track with the same amount of time he was working for LaForce?
Yes, ma'am.
And those 500 events as a DJ and event host, is it your belief that those were at LaForce and on behalf of LaForce?
Yes, ma'am.
Is it your understanding that Mr. Morgan has solicited away one of your employees?
Yes, ma'am.
How did you find out about that?
Through an Instagram post.
I'm going to show you what's been marked as Exhibit 8. Can you see that? I'm not sure if I just flipped to the next document, if you can see that.
Yes, ma'am, I can see it.
Okay, can you tell me what this is, please?
This is another post from Co-Host Entertainment showing Garrett Peters, who's formerly a Force employee and was also an apprentice to Adam Morgan at my company, behind a DJ facade and speakers.
Okay. And this is on Co-Host Entertainment's Instagram page, is that correct?
Correct.
And as part, I'm going to go back to Exhibit 15. As part of Mr. Morgan's post-employment restrictions, did he agree not to solicit employees?
He did.
Okay. Mr. Roush, will you explain to the court why you think it is that Adam Morgan working for a competing business, namely Co-Host Entertainment, is detrimental to your business?
Yeah, absolutely. So the it really has changed the. We're not talking about a small account. We're talking about a venue that has, or a company that has 17 venues in Dallas Fort Worth and approximately 25 across the Southeast Southwest. And so it was a large account. It was a devastating hit to my business to have to go through all of the questions and things that I had to deal with from wedding planners and other event professionals about what was going on and what was happening. I've lost bookings.
Do you mean what was going on with Mr. Morgan opening a competing business?
Yes, ma'am.
Continue, I'm sorry.
No, it's okay. And so I've lost, I lost a significant amount of business. It started with, being told by Mr. Morgan as well as Mr. Walters that, that the clients were going to be able to pick whoever they wanted. And then fairly quickly, it has been relayed that the clients are being penalized for picking a DJ that is not co-host. And so
this Walters account, that was an account that Mr. Morgan was primarily in charge of caring for as a LaForce employee. Is that right?
Yes, ma'am.
About how many events a year were you doing in Walters venues before they opened Co-Host Entertainment?
Well, pre-pandemic, approximately 200 to 300 events over the 17 venues.
Okay. And I understand it's difficult now with the pandemic and things are just opening up to really understand the full weight of the impact. Is that correct?
It is.
Have you seen a decrease though in the events that you have been allowed to book at Walters venues?
We have been currently working through the contracts with clients that we had already scheduled there because weddings are typically contracted out 12 to 24 months in advance. But yes, new bookings have seen a significant decline from Walters venues.
Thank you. I pass the witness, Your Honor.
Okay. Any cross?
Yes, please. Good morning, Mr. Rush. I spend quite a bit of time at Walters events. Do you have DJs at every Walters event?
I don't understand the question.
So Walters has 30 event venues across Texas and in Georgia. They host about 3,000 events a year. You said your company clearly does not meet that. So are you saying that you provide DJs to every single Walters event that takes place in the DFW Metroplex?
No, ma'am.
Quite frankly, you only provide services to a small percentage or an average percentage of those events, don't you?
I would say not an average event because a lot of them are going to get bands and some of them are just going to hire an entertainer that just is going to just show up and play music, or they're going to have no entertainment at all.
Okay, so there's a large number of Walters events where you have no participation. Is that right?
That's correct.
And I'll just move on from that. And do you have some contractual right that allows you to run your business in Walters facilities?
No, not currently, but prior to this whole action starting. I did have the venue agreement, like we discussed on the exhibit earlier, where Walters was asking me to pay a quarterly fee to be one of their preferred vendors.
So you were a preferred vendor, but at any time they could have elected to not have you be a preferred vendor, correct?
Correct.
And they don't have a duty to let you earn a living in their multi-million-dollar venues, do they?
No, I don't believe so.
And they don't have a duty to introduce you to all of their customers, do they?
No.
And did you make money off of Mr. Morgan while he was employed for you?
Can you clarify the question? Did I personally make money?
Did the business make money? But you made a point to say that he earned approximately $90,000 in the year prior to working for you. Did the business make money off of him, or was that a charitable donation that you made to Mr. Morgan?
No, we are a for-profit business.
And so you did make money off of him?
Sure, yes.
And there was some innuendo about some management software that you have secret information in. Are you actually alleging that Mr. Morgan stole some information from your management software?
We have not gone that far into discovery to determine that yet.
So there is no proof that that has happened at all?
No.
And there's an allegation here that Mr. Morgan has stolen your training material. Do you have any evidence of that?
No.
And then the recruiting your former employee, did that employee actually attend to any of the training or sign a non-compete for your business?
He had not started his training and signed his non-compete yet because DJ school was actually about to start before all of this went down, and he was fixing to be beginning.
And so he elected not to take the training and to take another job instead?
He did.
Is there any rule against that?
Yes, Mr. Morgan is prohibited from recruiting past employees in his non-solicitation.
Objection, non-responsive. I'm not asking about Mr. Morgan. I'm saying, is there a rule against employees leaving who have not had training and have not signed a non-compete?
No, ma'am. Texas is an at-will state.
Great.
I'm unclear about something. Was this gentleman actually an employee, or doesn't become an employee until after he goes through the training?
He was an employee.
He was an employee. Okay.
Yes, sir.
So he had actually been paid by your company.
He had.
Okay.
Mr. Rush, do you consider every business or organization that provides music or theater productions to be in competition with you?
No, theater companies are not in competition with me.
So are hotels that host conventions in competition with you?
Typically not. They're not typically offering entertainment.
And if Mr. Morgan had gone to work for a hotel, would we be here today?
If Mr. Morgan had gone to work in a capacity other than entertainment and the things that were prohibited, no.
Churches providing Sunday morning services, are those in competition with you?
No, ma'am.
And so to be clear, Walters is providing in-house services, is that correct? In-house?
That is my understanding.
And they would be doing that with or without Mr. Morgan?
I do not believe that to be accurate, but I'm not sure how to answer the question besides that.
Okay. I have no further questions.
Redirect.
No, Your Honor.
Call your next witness.
Ms. Manka is going to handle the next witness, Your Honor.
Who's that?
Adam Morgan.
All right, Mr. Morgan, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, nothing but the truth? We can't hear you.
do.
Okay.
Good morning, Mr. Morgan. Could you state your name, please?
Adam Morgan.
What do you do for a living?
I work for Co-Host Entertainment as the Chief Entertainment Officer.
And who owns Co-Host?
Walters Wedding Estates and Keith Walters.
Did you work with Walters while you were employed by LaForce?
I worked for LaForce. I never received a salary or compensation from Walters Wedding Estates.
Okay, but did you provide services on behalf of LaForce to Walters?
I did.
What does Co-Host?
Did you actually get paid by Walters or were you hosting? I mean, I think this was for brides of Walters, not Walters, just for clarification.
Okay. What does Co-Host do?
I got a little confused there. Can you ask the question again, Ms. Minka?
Yes. Did you provide services while you were working for LaForce to events at Walters?
Yes.
Does that clear it up, Your Honor?
Yes.
What does Co-Host do?
We provide wedding services to clients, not limited to couples, that host events at Walters Wedding Estates properties.
And what kind of services are you talking about?
Well, Walters Wedding Estates offers everything from catering, bar, floral, bakery, lighting, photo booth, entertainment.
But what does Co-Host offer of that?
Entertainment, lighting, and photo booth.
Okay.
Wait, are these two entirely separate companies, or is Co-Host a subsidiary of Walters?
It's a subsidiary of Walters.
Okay. Is that right, Mr. Morgan?
Yes, sir.
So I'm going to pull up what's already been admitted as Exhibit 5. Can you see that, Mr. Morgan?
I think it's loading.
Okay. Well, I seem to have been frozen. Can you hear me at least?
I can hear you.
Okay. So while that works itself out,
Why don't you try again?
I can't stop share. I just tried to do that and I'm completely
Go ahead. Try again.
stuck. I am completely frozen, but can you still hear me?
Yes, ma'am.
Yeah.
I think I just successfully shared by my computer, Spencer.
Okay, great. Mr. Morgan, can you see?
Yes, ma'am.
Okay. Do you have any more questions, or are you frozen? What's going on?
Your Honor, she's in the office right next to me. I'm gonna get her to come in here and use my computer if that's okay. So she.
Yeah, I think that might be better. While she's doing that, can you go up around for me?
I was really frozen. Okay.
Go ahead.
Mr. Morgan, on Exhibit 5 here. Are you familiar with this post? Can you read to me? I'm going to scroll down here. It's a little funky. But this is the second paragraph in the caption. Can you read this caption to the court, please?
I've already read that. We don't need to have them read the whole thing. Give me 1 second. I have to speak to my coordinator for a second. Okay, go ahead.
Is this paragraph an accurate description of what co-host does?
Yes.
Mr. Morgan, you need to speak up.
Yes.
Okay, and I'm going to pull up what's been marked as Exhibit 9, or pre-admitted as Exhibit 9. Okay. Mr. Morgan, can you see this?
Yeah.
Are you familiar with this Instagram post?
I am.
What is this a picture of?
A couple that got married. And they're, a dance party.
Okay. Did you provide DJ services at this wedding?
I did.
Were you employed by LaForce when you provided those DJ services?
I was.
So just to confirm, this is a photo from a LaForce event advertising services on co-host's Instagram page?
No. This is an event performed at the Alana, which is a Walters Wedding Estate venue.
But it was performed by you while employed by LaForce?
Objection, Your Honor. I'm going to object to the characterization of this. This is a Walters Wedding Estates website, and they have the authority and media waivers to publish these pictures of all events that take place over every period of time. So this has nothing to do with LaForce or Mr. Morgan. This is a Walters advertisement.
I'm sorry, guys. One second. I think I may have accidentally closed the breakout rooms. Is Miss Johnson in here? And who is the other witness?
Keith Walters.
Okay, let me put them back in a breakout room. I did not mean to do that. So I'm going to open the rooms. You guys need to rejoin them. Sorry about that. Just wait for them to leave. And while they're doing that, let's go ahead and take care of the 11 o'clock hearing while they're leaving. We have a hearing on the Neighborhood Credit Union versus Aldrina Rose Smith case, cause number DC 2010905. Is Miss Adamo, are you here for that case?
Good morning, Your Honor. Yes, I'm here representing Neighborhood Credit Union plaintiff.
And then Miss Smith or Mr. Smith, are you here for that? Mr. Smith, can you hear me okay? Or Miss Smith? I'm not sure what's going on here. I see your, okay. Mr. Smith or Miss Smith, can you hear me? While they're working out their video issues, Ms. Adamo, why don't you go ahead and make your argument on the motion for summary judgment, and then we can hear back from Mr. Smith.
Okay, thank you very much, Your Honor. Yes, we're here on plaintiff's motion for summary judgment. This is regarding a default account, an auto deficiency loan balance. We ask that the court take judicial notice of all pleadings currently on file with this case.
Ms. Adamo, are you still talking or?
Yes, did you hear me okay?
No, you stopped. I stopped being able to hear you.
Oh, I'm sorry, Your Honor. Yes, I was just asking that the court take judicial notice of all pleadings currently on file with this case.
Okay.
Thank you very much, Your Honor. Okay, we're proceeding forth with plaintiff's motion for summary judgment. I will note that there is a counterclaim on this case, and And we do wish to address that as well, if the court will entertain. We also have this case set for mediation this afternoon. And we will proceed forward with the mediation if the court wishes to do so, but I did want to go ahead and present the motion and then ask that the court consider a delayed ruling on its motion if we do proceed to mediation and depending on the outcome.
What is the counterclaim?
The counterclaim, it was filed by defendant. If you wish the defendant to go ahead and present the counterclaim, it's not a specific claim. It does mention an amount of $2,619 that she claims was not credited to her on a warranty, and that amount actually was credited to the account already.
Okay,
You want me to go ahead and move forward, Your Honor?
please.
Okay, thank you very much. So we're here today, we're requesting the principal balance of $11,693.44 together with contractual interest at the rate of 8.5% and attorney's fees, which have been proven up in our attorney's fee affidavit, which is on file with the court. We're requesting the amount of $1,500 on attorney's fees. And some prejudgment interest at that amount of the contractual interest of 8.5%. The total monetary relief that we're requesting today is $13,000.54 together with the sums that I just previously provided. Again, there is that counterclaim on. Go ahead, Your Honor.
Go ahead.
I was just going to draw attention again to the counterclaim, and then I'm prepared to speak to that if the court wants to take some testimony from the defendant, though I will note that we have not seen any response to the summary judgment filed with the court to this date.
Ms. Smith? Ms. Smith, you need to unmute. Ms. Smith, you need to unmute.
Okay. Can you hear us now, sir?
I can. Ms. Smith, you heard what the defendants, what the plaintiff said. Did you have any response?
Can I respond, sir? I'm her husband.
Oh, Ms. Adamo, what is your thoughts on that?
It's only Ms. Smith that is actually on the case today. So if she has a response, I mean, we certainly will hear whatever the response may be, but we'll take it as a response from Ms. Smith.
Go ahead.
Well, we had a service warranty, and the service warranty wasn't honored. We played it. It was the platinum plan. It's in the packet, and they sent it. We filed a claim, and the credit union said okay. They had to send us to a repair shop. The repair shop got back with them and said, yeah, this is one of the conditions under the plan you have. Then they sent it to some underwriter, and an underwriter was telling us that it was being processed. And then about a month later, they said we're not going to be able to honor it. And we met all the specifications of that service warranty. And due to the fact that we couldn't afford to pay $7,000 to have the car repaired, so we voluntarily had to give it back to the credit union.
Okay. All right. Excuse me. Go ahead, Ms. Adamo.
Yes, Your Honor. As I had said earlier, that the amount totally paid for the warranty, which is the amount of the counterclaim, the $2,619, was credited to the account. In terms of whether or not the warranty was honored by the warranty company itself, we haven't seen any evidence of that filed by the defendant.
What is the relationship between Neighborhood Credit Union and the warranty company?
Your Honor, it's a warranty company. It's a warranty that the consumer is able to purchase at the time of the auto.
And it's purchased through the credit union or through the dealership?
Let me confirm, Your Honor, if this is a direct loan or an indirect loan from the dealership. One moment, please.
This is through the credit union.
This is through the credit union. So it's a warranty that is a separate warranty company that the credit union does offer that warranty at the time that the loan is made initially when the vehicle's been purchased. So they did credit that amount back on the balance of the account, the full amount for the warranty.
The warranty cost $2,200 or the claim was $2,200?
The warranty was $6,000.
The warranty
Wow.
amount is the $2,619, Your Honor.
But they didn't honor the warranty.
That's the amount, the payment that was made for to have the warranty on the account.
And you're wanting them to pay for the warranty, even though the warranty didn't pay on the claim when they were supposed to, or I'm a little confused here.
Your Honor, that, let me see if I can grab that. It is attached to defendant's counterclaim, that it's a one-page document. Let me see if I can. The counterclaim looks like it was filed in October of 2020. It's listed as AGH is the, I don't know if the court will allow a share screen here.
Yeah, go ahead.
Okay, let me see if I can limit the debris in the background here for you. See where I can find. This page here, Your Honor. This has been filed along with defendant's counterclaim. Says signed here, contract cost $2,619. That's the amount that also has been credited back to the account.
And what was the okay, so what are you guys asking for then? $7,000, and what was that for?
Actually,
Yeah. That was for the cost of getting the car fixed because I got the top of the line warranty. They didn't honor the warranty when I needed my vehicle fixed.
And and the neighborhood credit union is asking you to pay the $7,000?
yes.
No, Your Honor, no, that's not correct. Neighborhood credit union.
I'm sorry, let me, thank you. Can I hear from Ms. Adamo real quick?
Thank you, Your Honor. Neighborhood credit union is only asking for the amount still due on the original contract for the vehicle, only the auto deficiency amount total balance, which does include a number of credits that have already been applied to the account. One of those credits is the full credit for the $2,619, which is here listed on the ASG vehicle service contract appliation.
But
And
the
that's
warranty company was supposed to pay $7,000.
that's defendant's claim, Your Honor. I haven't seen enough factual basis in order to honor that myself on behalf of my client. But on defendant's counterclaim, it only lists an amount of $2,000.
Let me just say, this sounds, what I'm going to do is I'm going to reset this to after your mediation. This sounds a little suspicious to say the least. And I urge you to try to settle this one, Ms. Adamo. But I'll hear everything next week. I'm in the middle of a TI right now, and you wanted to go ahead and have me delay anyway. So I'll be glad to hear more of it next. We can reset this to next Friday at 10, and I'd urge you to try to get this one settled.
Okay, thank you, Your Honor. You said 10 o'clock on Friday.
Does that work for you, Ms. Smith?
Yes, sir. Thank you.
Good luck.
Your Honor, does the court require us to send out additional notice knowing that defendant's here today?
Yes.
Thank you very much. We'll do that, Your Honor.
All right, reset to next Friday at 10.
Okay, thank you. May we be excused?
Thanks. Bye-bye.
Thank you.
Bye-bye.
Okay, let's get back to this. Mr. Morgan was testifying, and if there's any way that Mr. Morgan could speak up or have a better microphone, it's very hard to hear him. Okay, let's proceed with Mr. Morgan.
See,
Wait, hold on.
I got the rest of the service, those repair it. There's amounts in.
He's still there. Where is he?
Turn off and restart.
Go ahead.
Okay. Mr. Morgan. You were talking about this photo and you had just testified that you worked this wedding depicted in this photo while working for LaForce, correct?
I was a LaForce DJ at this time at this wedding.
Okay.
This is.
I'm going to pull up another photo to show you. The exhibit number. This was pre-admitted as exhibit number 10. Should have opened it already. Doing it quickly. Mr. Morgan, can you see what's been admitted as Exhibit 10?
Yes, ma'am.
This is a photo from co-host Entertainment's Instagram page, correct?
Correct.
Are you familiar with this event depicted?
Yes, ma'am.
What is it?
It is a couple dancing.
And this was at a wedding?
Yes,
Did you provide DJ services at this wedding?
I did.
Were you
Okay,
employed?
We're just going to renew our objection that this is a Walters website. Walters has the right to advertise anything that happens in its venues.
And we're going to respond that we're not objecting to the use of this photo. We're using this photo to show that the services depicted in this photo were provided by LaForce and are now being used by co-host Entertainment, but it's only for the extent of the services.
I get it. I get it. You can move on. I understand what's going on.
Okay. In that case, I have no more questions.
Eddie Cross?
Yes, Your Honor. I'm sorry, Your Honor, we're sharing a computer trying to make the mic situation better, so.
That's okay. Just be safe. I will tell you my number one concern here that I don't know that I fully understand and I think could be fairly dispositive to my decision is what is the relationship between, I want to establish it. I know what you've said, but I want to know what the legal relationship between co-host and Walters is. What exactly is the relationship? Is it a wholly owned subsidiary? Is it a company that they just do business with? What exactly is the relationship between these two companies? I think that's pretty important to my analysis.
Yes, sir.
And you may already have exhibits on that. If you could go into that issue, that's important to me.
May I reserve my cross of Mr. Morgan? I do have a Walters representative here, if we could bring her in.
Sure. So you're going to reserve your cross, which is fine. Call your next witness, Ms. Harrison.
Your Honor, we have no further witnesses.
Do you rest?
We rest, Your Honor.
Ms. Lewis, call your first witness.
Your Honor, I call Rachel Johnson.
Okay. I'm going to go to that room so that I can tell her to leave, okay?
Okay. Rachel,
Ms. Johnson, are you here? Ms. Johnson, you need to go ahead and turn your audio and video on, Ms. Johnson. I see you here, but we can't hear you or see you.
She's next door. Let me go help her.
Okay. She's back.
I'm here, Your Honor.
All right, Ms. Lewis, come back.
Awesome. I'm here.
All right. Ms. Johnson, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I swear, Your Honor.
Let's proceed.
Honor, in the interest of time, I'm going to significantly reduce my questions. Will you tolerate a little leading?
That should be fine.
Ms. Johnson, do you work for Walters Wedding Estates?
I do.
And what is your title there?
I'm the Vice President of Marketing and Sales.
And are you able to confirm for the judge today that co-host is a wholly owned subsidiary of Walters Wedding Estates?
Yes, I can confirm that.
And does Mr. Adam Morgan own any part of Co-Host or Walters Wedding Estates?
He does not,
Has he ever?
not to my knowledge.
And you would know, since you have been in this role since the day Co-Host was created.
That's correct. I've been with the company for 10 years.
And to your knowledge, during that time, Mr. Morgan has had no ownership interest.
That's correct.
And prior to January 1st, 2021, was Mr. Morgan ever paid any money directly from Walters Wedding Estates for any work on behalf of Walters Wedding Estates?
No.
At some point in 2021, did Walters Wedding Estates decide to bring more of the services it provides to its weddings and corporate events in-house?
Yes, we did.
And what did those services include?
We included catering. We previously had that, but we brought that all in-house for 2021. Bar services, which is also a service, DJ services, stationery, and floral.
And was any of this, was this part of a global Walters strategic plan that had been in discussion for a long period of time, but then was just elected to be fully implemented during COVID?
That's correct. We've been in discussion about this for a couple of years now. And with COVID, we had more time to strategize on the decision to bring those products and services in-house.
And is this a strategic plan to capture more revenue within the venues for the work that we do?
Yes, we're already capturing those clients. And so we received multiple requests to be able to provide those services in-house, and it's a strategic plan.
And was this idea somehow stolen from LaForce?
No.
And who actually sells the DJ services to the brides or customers of Walters?
We have a sales team who does all of our sales in-house, so they sell all of our products and services.
So are you saying at the time you schedule an event or you agree to rent the venue, you are also buying all of these services from the same salesperson?
That's correct. Our salesperson at that time contractually talks through everything that they want within their services. It's all done through our sales team.
And does Mr. Morgan work on that sales team?
He does not.
Does he handle sales for Walters Wedding Estates?
He does not handle any of the sales.
And when you were looking for someone to help run the logistics portion of the co-host side, were you looking to joint venture with another business, or were you looking to hire an employee?
Your Honor, I'm going to object to relevance because the issue in this TI hearing is not whether any opportunities were taken. The issue is whether Mr. Morgan is competing.
Well, that's interesting because this petition is certainly about whether he stole this.
Louis, I already overruled it.
Sorry.
Go ahead. Sorry. I just didn't want it.
I can answer the question.
Yes, please.
Yes, he was, we went after him as an employee.
So you were not looking for a business partner to joint venture with?
No, we were looking for an in-house employee.
And was Mr. Morgan the only person you interviewed for that position?
He was not. We interviewed a couple of people for the position.
And did you ask Mr. Morgan to steal any confidential information and bring it with him?
I did not.
And did you need the information that LaForce had to understand how weddings are supposed to operate, given the 15 years that Walters has been in the wedding production business?
I did not. We've been in business for 15 years. I've been with the company for 10 years. I was their marketing director previously, and I understand the market and the products and services that we offer.
And Ms. Johnson, can you just clarify for the judge today, does co-host provide DJ services to the general public?
They do not.
Can I call up co-hosts today and get them to host an event for my birthday at my house or my church or the YMCA?
You cannot.
So you're testifying today that co-host only provides services inside the property owned by Walters Wedding Estates?
That is correct. They only provide services within our products and packages.
And are you aware of any obligation you have to LaForce to allow them to run their business through Walters Wedding Estates venues?
No.
I have no further questions.
Go ahead, Ms. Harrison.
Thank you, Your Honor. Ms. Johnson, I have not been able to find Co-Host Entertainment registered as an entity on the Secretary of State's website. Do you know if Co-Host Entertainment is a registered legal entity in the state of Texas?
I can't speak to that.
Okay, what is the legal name of Co-Host Entertainment?
I don't know that information.
Okay. But it is a wholly owned subsidiary as far as you know of Walters. Is that correct?
They're our affiliate company.
Earlier you testified that it was a wholly owned subsidiary and now you're saying it's an affiliate. Can you explain that distinction to me?
Co-Host Entertainment is part of Walters Wedding Estates. I don't know the legal differences, but I do know that they are part of our company.
Okay, thank you. No further questions, pass the witness.
I have a question. Who is Morgan paid by? Who does he get paychecks from?
Your Honor, he gets paychecks from us as Walters Wedding Estates.
From Walters Wedding Estates or from co-host?
I'm not in the HR department, so I can't speak to how his paychecks look. I apologize, Your Honor.
Your Honor, and I'm not here for testimony, but I can confirm that he has, that Walters uses Paycom for its employee payroll, and he has an account with Paycom that he is paid through, just like every other Walters employee.
So he doesn't get an actual paycheck, he gets direct deposit?
Correct.
So Mr. Morgan, who is your employer then? Is it co-host or is it Walters?
Walters Wedding Estates.
Co-host is actually a trade name. It does not have a separate business.
Ah, okay. That makes it even simpler then. Okay. Call your next witness, Ms. Lewis.
Your Honor, I'll recall Mr. Morgan.
Mr. Morgan, you're still under oath.
Will you allow me to screen share, Your Honor? I don't need it just yet, but when the time comes.
Anybody can screen share whenever they like.
Awesome. Mr. Morgan, when did you come to work for Walters Wedding Estates?
At the 1st of January.
And what do you do there?
So my title is Chief Entertainment Officer. And so I manage the co-host accounts that come through from the sales that are completed. Primarily managerial. I oversee the calendar and scheduling the DJs for the events. I do not provide DJ services for any of the events sold. I, assist with planning forms that may go out to clients and making sure that they get those. Just trying to relieve a lot of the busy work from the DJs so that they can focus on being quality entertainers, and then assisting just where needed to ensure that quality assurance is done throughout the process for brides, grooms, couples, and any other events.
Okay, and so the crux of the matter is, are you providing DJ services at Walters events?
I do not, I have not, and I do not DJ any events that have been sold by the Walters Weddings specialist.
And And there's been quite a bit of discussion here about you having no experience before you met LaForce, and we have limited time, and I don't want to stretch the judge's patience with us. Your Honor, we have submitted exhibits of pictures going back to 2007 with Mr. Morgan hosting events, production, events as many as 5,000 people. So I'm just going to ask you to very briefly, in 2007, we provided a couple of pictures of events you hosted. Could you please tell a little bit about that?
In 2007, I worked for a university and I managed 3 different bands for the university. And so we would go to different events. We would set up lighting, sound, music, and then it was for a university that provided ministry services. So I would teach and preach, and the band would provide music. And so I assisted in all of the setup and ran the audio for the band while they played. So was a part of that for several years. And that was at my time at Tennessee Temple University in Tennessee.
Okay. There are also evidence of events that you hosted in 2008, 9, 10, 11, and 12. And without going into detail, did all of those include music production?
Music production, along with similar to what Mr. Roush said about like open houses. So we also did, I was a national recruiter for the university. So we would go to different trade show style events and where we would talk with prospective clients. Before joining LaForce for over 12 years, I have been doing a business.
I'm sorry, I'm just going to slow you down just so we can keep moving forward. And prior to working for LaForce, I've heard them say you've never worked a wedding before. Is it true that you and your ex-wife owned a wedding planning business before you worked for LaForce?
Yes. So
no, is it true?
Yes.
And did you work in the wedding event planning business?
Yes.
Involved in weddings?
Yes.
In event venues in Dallas, Fort Worth?
Yes.
And did you actually DJ a wedding before you came to work for LaForce?
I did.
So all of this was not foreign to you?
No, absolutely.
And you also had experience in high school and college choir and theater?
Yes.
And in that arena, were you taught music theory and history?
Yes.
And how to use a microphone?
Yes.
And how to use equipment and lighting?
Absolutely.
Were you taught how to stand erect and use good posture?
Mr. Morgan, did you answer?
Yes.
Yes, you. So yes, you.
Yeah,
So did you learn good posture?
Oh, yes. Yeah.
Miss Lewis, I'm going to take a real quick break. There's another judge here. I just want to make sure everything is okay. Just give me 1 second.
Yes, sir.
Miss Wong, can you go ahead and let in Judge Williams? She's here. I just want to make sure everything's okay. Okay, go ahead. I'm sorry, Miss Lewis.
Thank you. And Mr. Morgan, did you have some reason to hide all of this treasure trove of experience you had from LaForce when you applied to work there?
No, I communicated that to them.
And did you receive some training from LaForce?
I did.
And did you also buy additional training when you were there?
I did. I bought a course. It was the fundamental basics of learning to mix music, and then just my other, online learning that I've been a part of.
And Your Honor, evidence of that training and Mr. Morgan's purchase are Exhibit 10 and 11, but I'm not going to put them up at this time. And they were purchased in 2016, the same time he went to work for LaForce.
Okay.
Did you give LaForce notice that you intended to leave them in 2020?
I did.
And was that before or after you learned of the Walters opportunity?
Before.
And how can you be sure of the timing?
I have the text messages with Rachel that I communicated to her that I had communicated that I was leaving LaForce.
And at the time you met with Rachel, did she ask you to connect her with someone at LaForce, or did she ask to talk to you?
No, she communicated in her text messages that she wanted to speak with me specifically about the matter.
At the time you met with Rachel, did you tell her you had signed a non-compete agreement?
No, I did not know if I had signed one or not.
Did LaForce later remind you of that?
Yes.
In your current position with Walters, do you personally provide DJ services?
I do not.
Do you ever attend events and provide services for Walters?
I do not.
Do you sometimes attend events to supervise or train DJs?
I do.
Do you sometimes attend events to check in on client service?
Absolutely.
And then one of the last things we need to cover is Garrett Peters, the alleged recruiting of Garrett Peters. How did you receive Garrett's resume?
The HR team posted an Indeed ad, and every Tuesday and Thursday they send me resumes, and Garrett had inquired through Indeed because he was searching for DJ opportunities through there.
And so are you saying you received Garrett's resume in a packet of other resumes from Walters' HR department?
I did.
And that they received that from Indeed, or at least that's what they told you?
Yes.
So did you solicit Mr. Peters?
I did not.
Mr. Morgan, at the end of the day, what the judge really needs to know is, are you using LaForce's confidential information or trade secrets to perform services for Walters?
Absolutely.
Are you competing with LaForce in the marketplace for DJ services that they should be able to fairly obtain?
No.
Are you selling DJ services?
No.
Your Honor, I have nothing further for this witness.
Lady Cross?
Yes, Your Honor. Mr. Morgan, is co-host competing with LaForce?
No.
How so? I'm having I can't hear you. Can you speak up?
Yeah. The client booking Walters Wedding Estates, number one, doesn't have to book Walters Wedding Estates once presented with packages. If a client's my understanding that if they do not want to book one of the packages with co-host as a service, they can opt out of that. They are not penalized like Mr. Roush assumed earlier, but they're actually, it's my understanding, given money back off of their package price. So not penalized, but potentially rewarded.
Okay. So does LaForce and co-host offer the same services?
There is overlap, yes.
How many DJs does co-host have?
6.
And you testified earlier that you train them, correct?
The facilitate the training material that we are utilizing. So there's several different resources that are being used. I believe we have one of them as an exhibit. The biggest one is called the DJ's Vault. It's a open source. Did I answer that?
That answered, yes. 6 DJ, just to clarify, 6 DJs, you train / facilitate training them.
Okay.
Correct?
Yes.
Okay. I'm going to share my screen quickly. This is pre-admitted exhibit 18. This is the co-host entertainment website, correct? And this is your bio. And here it says, I'm going to read just the first sentence. In the past 5 years, Adam Morgan has successfully led over 500 events as a DJ and event host. You testified just now that you've been event hosting and DJing for 10 plus years. Is there a reason why you had to hide that experience from your bio here?
I did not hide anything. The message crafted is specifically geared towards weddings because that is the primary market. There is massive overlap when it comes to the development of someone speaking on a microphone and being a wedding host. With the same with music history and music theory and being in a band and singing and blending music, just like a band blends music, a DJ blends music. And so I've done all of the above before and during my tenure at LaForce.
Okay.
So if sorry.
The past 5 years, you were employed at LaForce, correct?
Roughly, yes.
Okay. And here it says, prior to becoming a DJ, you held leadership positions in higher education, nonprofit, and healthcare sectors for over 10 years, correct?
Did you have anything else?
I have no more questions, Your Honor.
Any other examination of this witness?
No, Your Honor.
Okay. All right, let's call your next witness, Ms. Lewis.
I have no further witnesses, Your Honor.
There was another guy in there. Do you still need to call him or no?
We can leave him. I'll text him and tell him he can leave purgatory. It's actually Keith Walters, and he was here just to add clarification if necessary.
Okay, let's hear final argument.
Thank you, Your Honor. We are not here with regard to whether any business opportunity was stolen. That's an issue for the other claims in the lawsuit that were filed. That is not the issue necessarily for this temporary injunction hearing. I will say that what we are here to talk about is whether Mr. Morgan had a valid non-compete and a non-solicit and whether he's violating that. Mr. Morgan is working for Walters as he's testified to, and that was a referral source he was specifically responsible for when he was working for LaForce. And in addition to that, he's also directly competing with LaForce. Whether he's personally doing DJ services is not the only factor to look at with regard to whether he's competing. He just testified that he's managing and supervising and training the DJs. Therefore, he is directly competing in violation of his non-compete agreement. I don't know if Your Honor has any questions about whether the specialized training is sufficient to be consideration for a non-compete. I'm certainly ready to address that. I will say that there's a case out of the Tyler Court of Appeals from 2016 that discusses the fact that even additional training is sufficient. In fact, in that case, a technician who was a neurodiagnostic technician had one specialization when he went to work for his employer. He signed a non-compete. They promised to give him more training. They gave him more training. He got 2 additional certifications while he worked for them. And that non-compete was upheld as valid just based on that additional specialized training. So, Your Honor, we have presented, I believe, a probable right to recovery. We've shown the court probable, imminent, and irreparable injury in the interim. And at this point, we're asking that the court enter the temporary injunction that we asked for in the original petition, and not simply to just extend the TRO. We'd be asked that he be prohibited from working for Walters. Thank you, Your Honor.
Response?
Thank you, Your Honor. This is a huge expansion of the non-compete, Your Honor. They signed this non-compete and they explained it to my client as, we don't want you to go open a DJ service competing with us. We don't want you to start going to the venues and saying, hey, let me do your DJ work. Hey, let me have those events that LaForce used to have. Like, I totally get that. That is a valid reason. But the issue here is Walters is no longer a referral source, because Walters is not referring DJ services out. Walters is doing it themselves. That opportunity is dead. The horse has left the barn. Mr. Morgan has complied. He's not providing DJ services to anybody. He is not going out to the event venues and saying, hey, give me those referrals that you used to give to LaForce. All of those things are exactly what Mr. Morgan is doing. The reality is Walters has venues in Dallas, Tarrant, Denton, and Collin. They also have venues in Harris, Walker, Montgomery, Williamson, Comal, Kendall. They have venues in Houston, San Antonio, Bernie, Georgetown. They have venues in Georgia. Are we actually saying all of a sudden this non-compete has expanded so far it's global now? And Your Honor, we all know that non-competes are a restraint on trade, and they burden the most vulnerable members of our population and the most vulnerable members of our workforce, employees. They're to be narrowly construed, and only so much as is necessary.
Lewis, I agree with you about that, but unfortunately the Supreme Court doesn't agree with you on that. I wish that was the law in Texas. A lot of other states it is, but let's kind of stick to what the law is and what we have to apply. So let me ask Ms. Harrison this. What is it? I've pulled up on the screen. I hope you can see it. This is what the TRO found. I'm perfectly willing to extend that as into a temporary injunction. What else is it that you want exactly?
Number one, we would want DJ services to be replaced with event production services. And on number two, we would want it to say including Walters, not excluding Walters.
Your Honor, I hope you remember that at our prior hearing, we could not define event production services. They said it was.
Is his job event production services now? Is that what he does? Or I understand he trains DJs, but what else does he do?
What he does is it's managerial. He handles scheduling. He handles assorted things like that. It's not DJ services, but I just don't know what the truth is everyone at Walters does event production services because that's what they do. They show up and they make sure these events go off. They make sure they get down the aisle on time and the dad knows how to toast and the cake doesn't get toppled over. They have 300 employees and every one of them are in event production services, quite frankly, Your Honor.
Your Honor, we would be satisfied with managing or training or supervising DJs.
And why is it
services
for him to be limited from that?
I agree. It needs to be possibly somewhat. I'm trying to figure out something besides just DJ services.
I believe that Mr. Rush was concerned about him emceeing events. We agree. He agrees that he will not MC events.
I think we're past the point of, I think he's testified that he is not providing DJ services. Although, I think that's not for Walter, certainly, at least that's been what the testimony has been. But what he is doing
is he's competing by facilitating the provision of DJ services for Walters. And that is what we have a quarrel with, because that is directly competing.
Explain that again at the end.
Sure. He is facilitating the provision of DJ services. And that is part of the concern here. He's managing, he's training, he's supervising, he's making sure they get to their events. He is facilitating the competition.
That seems so broad. We're reaching the point that, I mean, he couldn't have possibly contemplated that when he signed this non-compete.
It is actually directly in the non-compete that he's not allowed to provide or advise others of the opportunity to provide. I mean, it is a broadly drawn non-compete, but it's specifically so that he couldn't take this knowledge that he had and go help a competing company set something up. And whether Walters sets up a competing company, we don't really care. It's the issue is that Mr. Morgan's employed by them, helping them do it.
Ms. Lewis, how can we expand this beyond DJ server? You said MC services.
Well, and we're willing to, and I think the prior TRO says that he will not use their confidential information or any of their trade secrets in facilitating DJ services. He will not. You know, and I think we have that language in there. I'm happy to include that. Maybe that helps some of their concerns about his facilitating. I mean, he's a human who understands logistics. He should be able to schedule events. But I agree that he shouldn't be able to the extent there's some secret way that LaForce does it, he won't do it their way. Walters has its own internal systems for managing its calendar. They have their own software. They don't use the same software as LaForce. There shouldn't be any bleed over there.
The issue still is that the non-compete doesn't allow him to undertake any planning, provide any support or assistance and that is exactly what he's doing. I hear you say that he's not doing his own events. His Instagram posts say differently, but for Walters, he's not doing it. But that's not the biggest issue. The biggest issue is that he's managing this group of 6 DJs and helping facilitate the provision of competition.
So I see where your document says using, disclosing, or otherwise distributing LaForce's confidential information, which includes specialized training. We've covered he's not using your specialized training because he's using open source training to identify or contact the LaForce referral sources. He's not doing that. He's not.
Ms. Lewis, the issue isn't that he's using the confidential information. I think we've already had testimony that we don't know necessarily whether he's using the confidential information. The issue is he has a valid and enforceable non-compete and he's violating it.
So are we saying Mr. Morgan cannot work until the end of August 2021?
Not in DJ services, event production. If you want to take event production, okay, but I'm saying he can't work in DJ services, facilitating them, managing them, training them in these 4 counties or for Walters. And if the judge wanted to say, I mean, that is what the non-compete says. So yes, that is what we are asking for.
I guess I just don't read it that way. So
can you share the non-compete again so I can read the exact language?
Yes, Your Honor.
I'll stop sharing. That might make it easier.
Okay. Can you see that, Your Honor?
It says provide or attempt to provide or advise others of the opportunity to provide event production or for the benefit of any referral source. What does that even mean? Provide or attempt to provide or advise others of the opportunity to provide event services or for the, to or for the benefit of any.
So, Your Honor, he is not providing or attempting to provide event services. And it says, or advise others of an opportunity. That means, hey, dude, I know about a gig across town. You can go get it. He's not doing that. These are things that are all sold in-house by Walters.
There's also number 2, that's provide event production services, and that is what he's doing as an employee of Walters. And 3, undertake any planning or provide any assistance or support for any event production services located in the following counties. And then we have Tarrant, Collin, Denton, and Dallas. And the employee of Walters, Miss Johnson, I think her name was, just explained that everybody at Walters provides event production services. So I think we do know what it means. And I think that Mr. Morgan shouldn't be working for Walters under co-host facilitating DJ services.
And so in that broad definition, we are literally saying that our florist, our caterer, our bar, our everybody is in the event production services business.
Is event production services defined within the contract? Because it's capitalized.
I believe it is. I'm going to flip on my paper copy and find it so I can take you to it. Oh, here. It's in the initial recitations. Here, Your Honor, employer is in the business of providing event production services, hereinafter defined as specialized DJ services, including lighting, photo booths, and audiovisual.
Well, under that definition, it's very narrow, it seems to me. All right, so this is what we're gonna do. We're gonna follow the contract exactly. Let's go back to, let me share a screen. There's a way to do this. I wish I was a little better at that. You can share screen both at the same time. Let me see. Let's see. Where is that? Do you guys know how to do both at the same time? Any of you guys know how to do both at the same time?
I don't, Spencer, do you know? If Spencer doesn't know, nobody here knows.
Oh, I guess we both can share. Okay. Anyway, where it says providing DJ services, we're going to change that to event services with the definition that's provided within the agreement, which if you said it says DJ services, including lighting, blah, 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 blah. That's,
yes, Your Honor.
So that's how it's defined. Does that make sense, Ms. Lewis?
Yes.
So, I mean, I don't think he's violating it right now based on how event services is defined within the contract. But, you know, we'll see what happens. So, Mr. Morgan, are you there?
Yes, sir.
So can you pull up that definition again, Ms. Harrison?
Yes, Your Honor.
I have it in front of Mr. Morgan as well.
Well, I just, let me, thank you. So you are not going to be allowed for the next 2 months, I guess, or 3 months, to provide specialized DJ services, including lighting, photo booths, and audio visual. Does that make sense?
Yes, Your Honor.
So I think that defines it. I don't think anything, as I understand of what you're doing right now, would violate that, but just be aware of that in the next 2 months. And I think I mentioned to you before, and I haven't heard that you have done it. You know, you may feel like you kind of won today, and you did kind of win today, but you need to be extremely careful about what you're posting online. It's very easy to get caught in the, in this arena because it's kind of public. So be careful that you don't go and do lighting for DJs. You don't set up photo booths. You don't set up their audio visual. But you can continue to train DJs. I don't think that's prohibited by this. And Ms. Lewis, if you could go ahead and prepare the temporary injunction. My proposal would be that we keep this at the bond at the same level. Do you have any objection to that, Ms. Lewis?
No, sir.
And then did we already set this for trial? Is this case set for trial?
It's not set yet, Your Honor.
When would you like to set it for trial?
Your Honor, I have 2 points first. As soon as Your Honor can is fine. I will answer your first question first. And
Okay, so let's get that done first. When do you have any proposals?
I would propose that we do it after the summer, perhaps the last week of August, or no, not the last week of August, perhaps the first week or 2 of September.
That's awfully quick. Is there going to be any discovery needed before trial?
There will, Your Honor. That's a good point. I was thinking about the running of the 12 months, and I would ask you, I guess here's my question to Your Honor. He is still violating the other section that doesn't allow him to undertake planning or provide support or assistance for those same event production services, which are the DJ services, lighting,
I disagree with you on that, with the way event production services is, but again, you know, we can cross that bridge. It's very narrowly defined within the contract. That's kind of why I wanted to look at it. So let's get this set for trial. How much time we need to get this set
Your Honor,
for trial?
could we get something like January?
Ms. Harrison, what do you think of
January sounds fine to me, Your Honor.
Okay, so let's shoot for January. What's, let me look up. January 11th, 2022. How does that sound?
I happen to have a trial that exact same day. I could do later than that, though.
January 18th, 2022.
I'm in.
18 is good.
Okay. Go ahead and prepare the temporary injunction as instructed, Ms. Lewis. Share that with Ms. Harrison. Let's try to get this, or who did the first one, I guess.
I did it, Your Honor.
Why don't you edit it then, send it to Ms. Lewis. Any questions? I think Ms. Harrison, you maybe want to say one more thing.
I do have a question. My client has not gotten the benefit of Mr. Morgan actually complying with his non-compete for these last 6 months. And so we would ask that the temporary injunction be put in place to the time of trial.
Ms. Lewis?
No, I think we've all agreed that he's not providing competitive services. He's not taking a single opportunity from Mr. Rush. It'd be wholly unfair to extend this an additional 6 months just to be as a penalty.
There was documentation evidence attached to the TRO application that he has been providing DJ services independently of Walters.
Outside of those 4 counties, yes, ma'am, that was a wedding in Grayson County.
So the temporary injunction will stay in place. You know, there was different lengths here because I think one of them was 1 year for the non-compete. It wasn't the non-solicitation 2 years.
Yes, Your Honor.
So for the portions that are 1 year, like that subsection 1, that would go until the 1 year. For the ones that are in subsection 2, that would go until the time of trial. Just remember, I don't know how often you guys do temporary injunctions. I didn't know this when I was a new judge, that injunctions, we have to have a trial setting. The injunction would last until the trial setting. Ms. Lewis, if you want to move to vacate the injunction. So just so it's clear, that subsection 1 will last until the end of August. I want to include that in there. The rest of the injunction will last until the day of trial. If you want to move to vacate at some point earlier than that, Ms. Lewis, you can. Does that make sense?
Yes, sir. We're comfortable with that. Thank you.
Ms. Harrison, does that make sense?
It does, Your Honor.
Any other questions?
No, Your Honor.
Thank you, guys. You guys be safe. Get me that order, and it'd be great if I could get it by Monday.
Thank
I
you for
can
the
e-file it and also email it to my court coordinator. All right, guys. Mr. Morgan, you be safe out there. You don't, please don't violate